I think we've got everyone online. I'm just looking. Welcome. Thank you for waiting. Everyone in the room. So our format today is going to be 40 minutes of chat where we'll have some guided questions, and then we'll open it up to the room and online for your questions. So as you watch, as anything floats to the surface, feel free to put it in as a question. We'll start collecting those. Without further ado, I think John's going to give a quick introduction of me, and I'll give a longer one of Jon.
I don't know how quick mine will be. Elicia Salzberg is a graduate of the law faculty here at Allard. She was a student of mine in 2008, 2009.
Way my age.
And I shouldn't have said that. She came to law school when she was 9 years old.
Accurate.
So I have not given away her age. She practiced tech law at Blake's for a number of years, very intensely. I remember that period. And then came back to UBC and was a lecturer at Sauder and was eventually associate dean at Sauder and is currently on a sabbatical year. So very thankful that she's here. The little known fact, but very important fact, is that Elicia has a significant tie to this law school because her father, her late father, was a professor here for many years and a very valued one.
Thank you, Jon. That was lovely and short for you. So Jon, if you don't know, has been teaching at Allard since 1992. Some in this room and online probably know him from hits such as AI in the Law, IP Law, Tort, the list goes on. Jon has had a long career, deep roots in industry. He served as general counsel at Western International Communications, senior VP at CTV, executive VP business, and general counsel of the Vancouver Canucks. I've known Jon now for over a decade, since I was in video game law. And I think what stays with me and why I was quite excited to be here and agreed, he genuinely wants us all to figure it out. And by us, I mean not only students, but humanity. And this is in places where the law hasn't figured it out. So this includes AI, this includes many areas in technology. And I like that philosophy. I like that approach. And I am particularly fond of how it maps onto AI. So today we're going to be looking at that. And I think what I want to keep in mind as I'm talking to Jon is he sees technology as a way to amplify our ability to learn, to bolster. It's going to sound so cliche, and I mean it, the journey from knowledge to wisdom. So please welcome Jon, and we'll get started.
That was fun.
Okay, so off the top, Jon, there are dozens of AI copyright cases winding their ways through the courts. It's probably a conservative estimate. I'm going to ask for the impossible. You have 60 seconds in an elevator with a CEO, industry, graduated law student. What do they need to know today to not be caught off guard? And where do you think we're going?
Okay, so into my 60 seconds, as my students know, you can't count my ums and my closed eye reflections off into the distance as I think about things, and those uncomfortable pauses. So I think what everybody needs to know is that the directionality of the current crop of cases, and there are a lot of them, if you were going to map them, you would see that most of the cases, when it comes to ingestion of AI using creative content of others, so far, for the most part, the courts are saying that isn't copying, partially because of how AI ingests and doesn't really ingest, maps materials, and partially because of fair dealing in Canada, fair use in the United States. So that's number one. It looks like AI will be able to use materials fairly safely. That's certainly the trend. Number two, that changes nothing in terms of humans who choose to use AI to make a copy or generate a copy. That's still going to be copyright infringement. So, those are the two basic tenets in probably a minute and a half.
Okay, so let's unpack that a bit. So let's say, going back to the first point around the way that AI works has meant that it doesn't necessarily constitute infringement. Unpack that for me. Is it that the AI is coming up with something novel and that isn't appropriating the work? Or can you walk me through just a million miles up technical sort of piece around what is it inherent to this technology that keeps it from infringement?
So let's start with the basics. AI is ingesting an enormous amount of material. So think of it as, for our purposes, just a quick and dirty, ingesting the entirety of the internet.
Well, and off internet, there's whole world models now.
Yeah.
Yes.
So, but as the starting point, and that entirety of the internet, for other parts of our discussion, is worth noting that a lot of that is bots. A plurality of that is material regenerating itself. So that when you look at how much of an actual human created work is in something that is ingested by the AI and then is usable on the other side, goes through the process and a human uses it and externalizes it, brings it back into the world, it's going to be very tiny. It might be de minimis in legal terms. It might never be fixated in copyright terms, and there's a requirement of fixation, so it may never even rise to that level. And then we get to the second part of fair dealing, which in Canada is very education oriented. And although it's anthropomorphizing, what are we talking about? We're talking about AI companies training the AI. So that, in a way, sounds like it's educational. And in fact, some of the courts are going in that direction. So there's a whole bunch of reasons. I think the best reason, if you want to kind of look at how we learn, our eyes see a lot of things and we react to a lot of things. We read a lot of things. We read a lot of copyright material that we don't pay for. We ingest a lot of trademark material that we don't pay license fees for with our eyes. Why is it that just because you have a digital lens on it, that automatically changes the equation into something that's quasi-contractual and creates liabilities? So I think there's a lot of reasons, but probably the best reason goes back to that the original purpose of copyright law, going back to the Statute of Anne hundreds of years ago in the UK, was learning. And AI is part of, and I don't want to overstate it, part of that ongoing learning process for humans. So I kind of center it on the human need to learn and not, the AI commercial interests.
Okay. I like it. And I'm going to be devil's avocado for a minute. I would say that is to be applauded. That see learning and AI as for the betterment of humanity, and from that frame, what does it look like? So I'm going to bring it down to an example now to sort of illustrate, well, what about when it's used for commercial means in ways that non-traditional ways? So the internet exploded. Again, it does this many times a day. This time it was a fight between Brad Pitt and Tom Cruise that ByteDance's seed dance had generators like 15 seconds. And it was so apparently realistic and so good that various folks from industry we're all over X saying, it's over. AI has won. So mapping into what you're saying around infringement and what constitutes infringement and what doesn't, I mean, how do we look at it when you have these types of examples where it seems like these corporate entities are just breaching and infringing all of our norms right and left and laws? Go on.
Two parts.
Yes.
And these are not new problems.
No.
We've had them with VCRs. We've had them. They're in a way standard plagiarism problems. So step one is the tool, getting the tool to work. Nothing has returned into the world. It's just the AI machine, the tool, is ingesting this material. Is there copyright infringement in that? I've already said the courts have tended to say no, because nothing has been returned into the world. What gets returned into the world gets returned into the world with and here's where we have to be careful, because we're going to talk about AI agents and what they can do. But let's assume it's at this step that we're talking about a human who decides to post this material into the world.
Okay.
And that is gonna be an infringement. And it gets very complicated when we're talking about Tom Cruise and Brad Pitt, because there may be some copyright aspects, but it's really personality rights and privacy rights that are at stake. But I'll give you the copyright example, a real example. Video game company. You might remember this because this was just around that time, made a superhero game. And the superhero game had a toolkit in it where you could make any superhero. Marvel comes along and gives evidence that they had their comic book artists go into this toolkit that came with the game and create the Incredible Hulk. And the court was not impressed by that, because that doesn't implicate the tool per se. That's a human coming in and saying, I'm going to breach copyright. And in fact, it was the Marvel artist who was breaching copyright of their own stuff. So the court wasn't going to blame the tool. Generally speaking, there are some exceptions in the US. The courts have not blamed the toolkit. And in Canada, I don't know of a single case where in our fair dealing doctrine, the court has really, other than in a kind of a complete plagiarism situation, blamed the tool.
I'm wrestling with that. So I think the examples we have now are even more interesting in terms of where to place blame. So like, let's take Sora 2.
Yeah.
When it first came out, this was the video platform where you could upload photos, video, source material, where the subject of that source material may or may not have consented to the upload.
And it was hugely fascinating to me for about 48 hours.
And it was so easy to do at first. Like there were no sort of controls or steps where you had to represent that you had the permissions, or that you had to evidence that you had the different permissions. So where it's so easy and friction-free to come up with what was pretty slick videos that featured copyrighted material or folks who hadn't consented to their copyrighted material going up. Wouldn't you think, and I'm sorry, this is such a leading question, because obviously where I want to go, I want to pin that blame.
No, I'm ready for this.
Wouldn't you think that the company behind that product is going to bear some blame? I mean, they're putting something out there that's, they're putting glass all over the ground and telling us to walk on it. And they're like, careful where you step.
So I'm going to give you two examples, okay? And sorry for the deep dive into law, but I think they're the two relevant examples. The first is the VCR case in the US Supreme Court, Sony versus Universal in the 80s. So you remember VCRs. What were people using VCRs for? They were recording, for the most part, television shows and replaying them.
Yes.
very obvious on the surface. Prima facie is our fancy legal Latin term for it, breach of copyright. But the US Supreme Court actually invented a doctrine, invented a use, which they call time shifting. Mm. And they said, technically, this is sort of to meet the technical legal requirements of fair use in the US. They said, well, time shifting is fair dealing. And that means that not everything that was being done with these machines, there was a legitimate use for these machines that wasn't exclusively copyright breach. And you might remember, some of you who are older, much older than Elicia, might remember that we had our little Sony movie cam things, and we could play them through our VCRs as well. And so there were other uses, and that was enough for the court. So that's one example. The other example, which I wouldn't, when 2003, and there's some other great intellectual property lawyers here in the audience, and I'm sure on Zoom right now, I wouldn't have given them much of a chance initially, was when Google Books came out, right? That Google Books was taking the Western canon of literature, reproducing it, and making it available to everybody. And the court found that there was a public interest aspect to it, and said that this was transformative, and that the transformativeness, which was embodied in the ability to search books, was enough to make it fair use in the US and presumably fair dealing in Canada. Well, when you look at transformativeness, AI is a transformation machine. It's a derivative rights machine. All it does is create derivatives. And, I mean, we can go off the philosophical cliff by also saying, not asking personal questions of you, so I'll ask it of the broad audience. Anybody sing in the shower? Anybody sing a Taylor Swift song? That's all the AI is doing in a sense.
But I'm not putting my shower song, or maybe I will now, but I'm not necessarily putting it out for commercial consumption.
No, but if you do, then, and you could do a shower cam. I've actually done this in my IP law class. You could have a shower cam, and then you can put it, and you can put it, but you can put it on YouTube. And you will make money a little bit. Well, never mind. But somebody can make a lot of money on that, and some people do, just by singing. And there's your commercial interest. But are you going to blame the shower cam? Are you going to blame the tools? And I think that's a fundamental piece here. Do you see AI as a tool? And I don't mean you, Elicia, I mean all of us, and the courts ultimately. Do you see AI as a tool, or do you see AI as a co-creator or a creator? And that is where liability may flow.
And I'm actually going to preview something that we're going to talk about a bit later, because I don't think we can answer that question. Well, maybe we can answer that question full stop. And I don't think we can even have a shot at answering that question without thinking about regulation, without thinking about, okay, well, if this platform exists, and as you're saying, as a tool to sort of further creative pursuits, as a tool to put out new-ish work, fine. But then maybe then it's a wrapper, or maybe it's a floor, whatever you want to describe it, of regulation law that keeps it from going off the rails, which we're going to talk about.
Okay.
And this is sort of a segue, because I do have a question online about law and careers. I see you. We're going to get there. I'm looking at a time check. We're going to get there probably in around 15 minutes, so hang tight. But before we get there, we're going to talk about bots.
Okay. Are we still on the elevator, or have we moved up?
I'll exit our elevator. But shortly, you're stuck for now. I've pressed the emergency stop button. We're going to talk a bit about regulation, and then we're getting to the profession. So I mean, we've succeeded in making our elevator quite messy and setting out a general framework around where sort of the crux and the purpose of copyright law has come from and where we find ourselves now. And I think these questions are open and the right ones. Jon, I think you've done well to sketch out, to consider a success to sketch out where we are, where you think we're going. I think it's positive and optimistic, which is wonderful and very consistent with our interaction. So I'm going to leave it there because I want to leave it in a place of hope and move on to bots.
Our robot masters.
Yes. So I'm just going to do a quick roundup of agents. Everyone in the room probably knows too much about this and online, although it moves every week, right? So they're booking flights, purchasing for us, agreeing to terms on our behalf. If you were tuned in over the winter holidays around Moltbook, there was sort of open claw, these agents who were talking to each other about the meaning of life and humanity independently, or at least they said it was independent. So we have these independent things. When they do things on our behalf, what does liability look like? Are we bound to their actions when things go sideways? Tell me more.
Okay, so this is a very complex piece, but I want to start with tort law because that's where you're going to find the liability. And also, I think this is important because I know you want to talk about regulation at some point.
Yeah.
And as a vast general statement about law, I think it's fair to at least suggest that if the law takes care of the problems in some way, in other words, if there is significant tort liability that's possible, then regulation may not be as necessary, right? It's a sliding door. And if the law and traditional law is doing a really good job of dealing with the problem, then you may not have to do special laws, special regulations as much.
Sure.
And, my bias, which I'll declare as an old kind of freedom of expression lawyer, is I tend to believe that in the end, very focused, particular regulation is better than unenforceable, unenforced, or I'm looking at a friend in the audience, broadly stated regulation that is enforced only when a regulator feels like it for the interests that they wish to protect at the cost of. So I think there's a real rule of law principle around having specific targeted regulation and going hard at it. So if tort is taking care of something, then maybe I'll use the CRTC as a stand-in regulator for these purposes. Then maybe the CRTC doesn't have to get involved if the courts are doing a good job. Mm-hmm. And the better the courts do a job, the less we need to have amorphous regulation that can easily go sideways. That's kind of where I'm coming from. Oh. So number one, when we talk about AI, here's the really challenging bit. Donahue and Stevenson, and this was pointed out to me by one of the students in my class this year. Donahue and Stevenson is based on the neighbor principle, that a neighbor has a duty of care. Well, given the amount of AI bots that we interact with, is AI our neighbor now? In the real world, AI is kind of our neighbor. In fact, there are more bots on the internet that we interact with, arguably, not arguably, inarguably than humans. And it's growing exponentially. So if a court wants to create liability that way, and I think it's seriously worth thinking about using the Donahue versus Stevenson test, you can absolutely go there. And I would rather, and again, there are people here who are more learned about this than I am, but I would rather that the courts deal with directly, per tort law, right or wrong, the issue of AI assisting suicides, Teslas, or any any non-human guided vehicles creating damage, then creating regulatory bodies to oversee them as mediums, as platforms, at least as a starting point. I am not ruling out regulatory bodies, but God's sakes, I think we hopefully have learned if you make something the job of a regulatory body, you need to be really super specific about what it can do, can't do, and what it must do and what it must not do.
I think this ties, yes. I think this ties, you and I have talked a lot about law and speed and velocity and change and technology. And that lands firmly in this conversation where agents are doing more and more things on our behalf, more and more sophisticated things with more and more potential impacts to people, property, systems, you name it. And we see some common law as it's produced at the common law rate, but then we also see agents, giving information on. So there's the more light version. So an Air Canada bot gives, one of the cases gives you bad information. You end up having the wrong plane ticket and so on. There's that. And then there's systems now that are thinking about how to navigate streets. And then we're also moving into systems that are informing whole corporations and forecasting and so on and so forth. And the common law is chugging along at this common law pace, which I would venture to say is slow. How do we live and operate in this strange limbo, which is going to exist arguably until either this finds stasis, this being technology, which arguably it won't, and sort of this creeping speed of common law?
Okay, couple of answers. Yes. Because you brought up very different scenarios.
Yeah.
So I want to work backwards from the corporate scenario.
Okay. So
okay. Because not even that. No, the board of directors.
Okay.
Let's go from the board of directors, and we'll go right into Air Canada bot because it is, it's very related.
Yeah.
I have no sympathy. Board of directors, lawyers, doctors using AI have a complete responsibility to check out every single thing. I don't see any exceptions to that. I don't see any reasonableness arguments. These are sophisticated, knowledgeable people who have a duty to the public, right?
You think it's built right into that duty?
I think it's built right into that duty because nobody who's doing those things should have the excuse, oh, gee, I thought AI was 100% accurate. Does anybody believe that Google was 100% accurate? If you are a professional or if you have what I'll call statutory responsibility of any kind, I don't think you should be able to hide. And then, of course, the tort law, common law rules around remoteness, or all of those normal defenses and foreseeability can come into play.
Sure.
But that's really normal. From there to Air Canada, have no sympathy, but I think there's a key point here, where particularly because commercial interests are, I'm not going to blame anybody in particular. I'm just going to say telecommunications carriers are among the worst at this, will use AI bots seemingly to make sure we never really get an answer, and navigating them seems intentionally difficult. But maybe that's just my opinion, and maybe it's just wrong, and these are incompetent systems that they've put into place, which is entirely possible. But they, they should have liability for that, unless, and this is the thing, unless there's real transparency. So by creating this tortious pressure, the pressure of tort law, I think you're increasingly going to see suppliers, platforms, people who want you to interact with the bot being transparent about their bots before regulation. The EU is very close to regulating that and saying all bots have to be transparent to us humans as bots. I think in terms of tort law, it becomes absolutely critical that anybody who's using a bot be declaratory of that bot.
I like it. Transparency is good. And do you think that's enough? Like I look at, so let's unpack. I've written down liability unless there's transparency. Notionally, arguably, companies have to be transparent in their click route. Like we all scroll, update our iTunes. We all, sorry, that doesn't exist. Or it exists.
It exists for us stupid old people.
Yeah,
like
we wanted to preserve the thing.
We're still replicating all the CDs we have at $1.29 a pop.
You don't want, anyways, different conversation. Every time we're just sort of scrolling through and clicking, yeah. So the idea of transparency in concept is one thing. And then in practice, where there's consumers who are hurried, who just want an answer from a bot. I mean, they could know that they're interacting with the bot and still overly rely on the information there. And I think given how much information we deal with, given how quickly we need to make a decision, the transparency that you're dealing with a bot, it might just be a slide into where we are with click wraps.
Right. So I do think that, Supreme Court of Canada started along this path in a case called Duez and Facebook, in terms of picking apart appropriately, in my view, the terms of service and the contractual relationships. And I think that tendency is going to grow and grow because AI has a really mass market now, and is going to create even more responsibilities and duties than social media has.
I am going to agree. I think that's probably the longer arc and
it's a longer arc. And I, again, you accuse me of being an optimist, and I think that's fair. I do have faith in the law is careful and it evolves carefully, especially tort law, but it does evolve.
Yeah.
And the danger, I'm going to throw in, I'm going to take us a totally different direction. The danger of those who suggest that, all we have to do is take the law and put it in code, for example, is that the law would stagnate if we did that. And there are some advocates, even in Canada, of doing that. And that was debunked, I think, a long time ago by various Harvard law professors. But it keeps on coming back as, we can have AI judges and we can just codify the law. And, that's a real quick way into an anti-democratic surveillance state. We just back our way into it in a second.
Doorway to dystopia. Before we leave this one, I'm just looking at our, you're not out of scope online. You've abandoned your questions.
And there's a lot of questions.
And in the room. So I'm looking at our time. We've got around 10 minutes of guided chat and then questions. Please put your questions into Zoom. I'm only seeing the one on industry. So John and I have a lot more. Don't feel like you need to. And this is your chance to do it before we get there in about 10 minutes. Before we left this topic, though, I do want to look at it from a practical standpoint. So you're a board member, you're considering an acquisition. And there's been sort of a financial model put together with AI that's been checked by a human. There's various other materials. The diligence has had the help of AI. There's a human in the loop. So there are humans at critical junctures. That said, what you're evaluating has had fingerprints of AI on it. You don't really know. It's a black box. You don't really know the extent of those fingerprints. You don't really know. You can't reverse engineer into every single input. My question is, sometimes the borders of, is this an AI decision? Is this a human decision get blurred? And then we'll get more and more blurred. And as a board person, you're given packets and there's lots and lots of information. Can you rely on that information? And is it your duty to borrow that thinking from earlier? Is it your duty to come up with sort of the first principles analysis and sort of understand that, yes, this is correct? Like
Okay, let's.
How far back do you have to start confirming?
One of my courses that I'm not teaching this year, but I am teaching next year, is corporate law, business organizations. So let's just look at kind of first principles. All the duty belongs to the board. They can delegate certain things. And there are very narrow exceptions in corporate law that have to do, and the Supreme Court of Canada has reinforced this, that have to do with professional advice to the board. Lawyer or accountant or engineer advice, that at least in the current idiom, I don't see any way around those decisions being characterized as anything else than a human lawyer, a human accountant, a human engineer. There may be a day in the future where, the Law Society certifies an AI lawyer, hopefully long after I've passed into...
Don't leave that problem with me, John.
Well, you're 16 years old, so you can...
Yeah, I got time to crack that nut, yeah.
But I think the courts have been very clear about what corporate responsibility is, and that and the example I'll give, which certainly ages me, is that corporations were unbelievably, maybe too much so, it was kind of a joke, but unbelievably diligent, over diligent about the millennium bug, which was going to attack all computers and destroy the world as we know it, when the world turned from December 31st, 1999 to January 1st, 2000. And, if that was the standard, why would the standard be different now? There's nothing in corporate law that suggests it should be any different.
Okay. You've just made everyone's day a lot longer, having to look at all of the facts before them with their own human intelligence. And I agree. I think that's where we are right now. So there's a few questions online about the profession. We're going to start that conversation now in the 5 minutes we have left in our sort of 40 minutes. There is also 40 minutes for questions from the room and online. So there's a lot of room for us to play in whatever areas you're thinking of that we didn't get to. So let's go there. By the way, I've jettisoned regulation.
I suspect it'll come up in the room.
Yeah, I just have business we didn't get to, but we'll come back. So the profession, where do we start? So most recently, Microsoft's AI chief said that white collar work was going to be replaced with AI within 12 to 18 months. Sensationalists, obviously, motivated to say that. And we're also seeing firms are integrating, making available AI tools. So we're seeing that there is increased functionality, increased value with the work that AI can do with law, around law, informing the practice. What are your thoughts? Is the profession sort of sleepwalking into this disruption? Is this just hype? Like, try and sort through the noise for me. Where are things?
There's a lot of noise. So let's start as best I can, and feel free to prompt me on the noise. So noise number one is the hype that you've pointed out. And so much of that, I'm sorry to put it this way, is grift. It's simply, promotion of the industry because you've got to keep the gravy train going. And I don't want to tell too many war stories, but I was working with a tech company the weekend that the internet boom busted in 2001.
Oh, 2001.
I was actually at Microsoft. We were pitching.
Yeah.
They had said yes, and then they pushed, and then darkness took hold. So I think in the industry, in the tech industry generally, there's having, people who are now at the top were young and may have been laid off or seen their friends and colleagues laid off. So there's an enormous fear around that in the industry itself. And so they're going to naturally, even subconsciously, use every means available, not just because they have shareholders meetings next quarter, but I think there's a visceral fear of the bust. And I think most of us who are of a certain age understand that there's you get booms and you get slowdowns, and then the technology comes back in a more knowledgeable and better way. We for those of us who are gamers, you are one as well.
Admittedly.
We're seeing the second bust of virtual reality. The first one was Nintendo in the early 1990s, right? They had 3D glasses and it was the big thing, and then it busted. Now we're in the second bust. There will eventually be 3D. There already is starting to be 3D glasses that are usable. It will come back, but there's a cycle to these things, and it's not related to the cycle of development as the comp sci people and the technologists want it to be. It's economic, and it's about the investment cycle
and application.
It's about solder.
Yeah,
it's about what
yeah.
you guys coach, and people coming in too fast. In the expectation of making a lot of money, and then that gets culled. So
Sauter lives so close to coming in too fast and making money in that sentence, and also
and I'm not blaming you guys, but the cyclical approach to these things. So I think that bit of noise needs to be really, really discounted when we're looking at this. So
fair. And so many of my questions start with an and, not a but. Okay, we're at the end of our 40 minutes, so I'm in the question period, but this is going to flow in. Some folks are when ChatGPT first disrupted us in November 2020, whatever that was now. It seemed
22,
like
I would say 22, right there.
And many folks were saying, this is like the calculator when it first came. I don't know if those folks would say the same thing now when you're looking at Claude Cowork, when you see the plugin from Anthropic for legal, where your calculator doesn't reason. Your calculator doesn't have recursive learning, where it's teaching itself what the deficiencies were from human feedback and getting better. There wasn't the ability to work autonomously and coming back with a human. So I think it's an imperfect analogy in many ways. And I also think it reduces it to too simplistic, sort of a non-threat. It takes out the barbs in a fiction where with reasoning and a machine trained for language reasoning, are we seeing something different? And you did say it cycles, but
So,
is this cycle different?
the difference here, every innovation, every huge technological advance does add something. They're all additive, right? The printing press added the ability to replicate books, and that had a powerful effect on the world. I'd say, the kind of rule of law rights regime started because and certainly the common law was amplified because we could collect and distribute texts. Radio brought something, television brought something. The internet obviously brought a lot. So yes, everything is additive. The internet brought a connectivity and a control and individual control and interactivity. And this brings a animation, this is like your dog or your Barbie doll or your G.I. Joe coming to life. And we're going to see that, right? My grandchildren are going to be playing with AI dolls. And it's not going to be just that they're anthropomorphizing. That anthropomorphization is going to be built in. But it's still, at the end of the day, different from us. It's ones and zeros. It's an inference engine. We come to our human conclusions a certain way, and AI comes to it in a ones and zeros inference way. So it is math at the end of the day, and it is different. The question that underlies all of this that nobody really wants to talk about, but I'll talk about briefly and simply, is AI conscious?
We have 18 minutes and 10 questions.
And I can do it in 30 seconds. That I can do as an elevator pitch.
Okay.
If you're going to judge consciousness, you have to judge, are we conscious? We are conscious because we believe we're conscious. If AI believes it's conscious, if it believes its own story, then on its own terms, it's conscious. I can't judge whether an amoeba is conscious or not. Only an amoeba can judge whether it's conscious. Consciousness is going to be individualized frame of reference. We're never going to be able to agree. We're all silicon-based. So I'm not making the argument that AI is conscious. I'm just saying it's a futile discussion to have.
I will take that and I will leave that on the table for a moment, because I think a piece of what you said earlier goes into a few of these questions around what does it look like with AI in the law and careers and law school, and does AI become one of the core competencies that lawyers will be responsible to use, and it becomes part of our expected inventory of skills? So I hear you. I'm getting there. Let me condense that into a question. There's a common theme I'm seeing run through about 3 or 4 of these questions around AI is being used, and from there it's branching into, should we expect practitioners to be able to use it? Is it going to be part of the supervisory duties around training lawyers? And then working backwards in law school, what needs to change so that we're equipping future lawyers properly?
Okay, so great question. So rule number 1 is nobody should be outsourcing their thinking to AI. That's the great danger. And law school has to be about training students. We're not the ones who should be training AI lawyers, at least not for a long time. AI is a tool. And again, shoot me for being the optimist. There are right ways and wrong ways of using a tool. The wrong way for students and for everyone else is to outsource their thinking or their writing to AI. And in particular, I'll just point out that in law, for those of us who are trained in law, legal thinking and legal writing sharpen each other. So they're both really important. And you can't just say, oh, my legal thinking is going to be enhanced if I outsource my legal writing. It's not how it works. If you want to sharpen it, you have to sharpen both. It's a dialectic between your writing and your thinking in terms of analysis. So we have to focus on that. That said, of course, we can use AI, and many of my colleagues here that I'm working with, Nikos Harris and others, we are working on tools that never, ever give the answer, but ask the students questions or prompt the students. So one thing we're working on that's gotten a bit of publicity is in Canadian Lawyer right now, is a tool for the legal aid clinics here at UBC. It is strictly instructed to not give the student any answer, but to say, have you got enough facts? What about information on this, this, and this? What about researching this, this, and this? And leaving it to the student, leaving it to the lawyer to do that. Lawyers and students who outsource their thinking to AI are simply not going to be able to meet the standard of the profession in the future. And why should they? Because that information about what the law is in general terms is going to be available to everybody. So you want to be a professional, you're going to have to, and you want to have clients, you're going to have to do a lot better than that. You're going to have to bring something special to the table. You're going to have to bring your own voice, your own way of analysis to the table. And that's where the value creation for professionals is. And that applies equally to doctors. Most of us, before we go to a doctor, if we have some ailment, we're going to look it up online. That doesn't mean we can do surgery on ourselves.
Well, agreed.
I hope you agree.
You try. It's a first pancake. So John and I have actually gone back and forth on this many times in the time we've known each other, sort of around, and I wrestle with this too. John mentioned I'm just coming out of the dean's office for dean of students at Sauder. What do students need to know, and what has shifted since there's been AI? And some of you are asking, and this is where we're going with the end of my question. When you reverse engineer what the value is as some of the more repeatable, scalable type tasks get automated with AI, it's what John's talking about. Like it's discretion, it's judgment, it's bringing to bear your experience and expertise and relating that to other humans. How do we teach that, John? What changes at law school, and what changes in the mentorship? So, I mean, some of you might be doing your articles right now. What changes in that first year, that second year, so that we're setting people up for the future of law? So
I can speak to how I'm teaching 1Ls. That would maybe have been different 25 years ago had I been teaching. I am right off the bat, and I look at some of my experienced colleagues, beseeching them to find their own voice much earlier and not just follow the formulaic, not just figure, and a lot of law students, a lot of students come into law thinking that there's a, pardon the pun, a code to be cracked in terms of how it's presented. And how it's presented is not nearly as important as the analytic quality of what is being presented. And that's where the difference is going to be in the future. Because one thing that AI does fantastically and has done fantastically for years, because it's ingested all of the internet, is formatting things.
Sure.
It formats fantastically. It formats way better than I ever formatted as a law student. That was, one of my weaknesses. It is nobody's weakness today. And there's nothing wrong with having your paper formatted by an AI. But once you get the AI writing, there is a flatness and a circularity to those arguments, and it is very tempting to those who don't have full confidence in themselves, and there's not a 1L student in the universe except the misguided who have full confidence in themselves. They all want to defer. We all wanted to defer. We all assumed that everybody was smarter than we are. You can't. You've got to work on your craft. And I think that maybe is the key, if you'll allow me. AI doesn't understand what a craft is. It doesn't, whether it's conscious or not, it doesn't see itself, and we don't see it in a craftsmanship context. I think what makes us human and successful is that we see it as a craft. And those other qualities that you outlined, that the compassion, the ability, one thing AI doesn't do very well is recenter itself. We as humans are very good at going, you know what? I see this logic, and I see how A follows B follows C here, but I'm not comfortable with where this is going. And I need to recenter it to something that's reasonable, that's fair. One thing AI doesn't do, give it a fairness problem, has no clue what to do with it, even in the most advanced AI today. It can tell you what other human decisions around fairness has been, but if you work with it, it will not give you a satisfying answer on fairness. And law, fair dealing, fair comment, we've got fairness in procedural fairness. It is all over the core of what we do as lawyers. And I think it's going to be a while before AI does that very well. And hopefully, and I mean this, and people may be upset at me, hopefully we never have AI judges. I think that would be really dangerous. And there I am not being optimistic.
I have a question that sort of brewed as you were speaking. I do want to look around the room. We have around 8 minutes. I haven't gone to the room yet. We've actually knocked off about half of the questions online, believe it or not, efficiently in that paragraph.
Knowing you, I would expect nothing else.
I like to hit the mark. Were there questions in the room? Yes. And I'll repeat it out loud so they hear it.
Sure. So a question on corporate law and tort law. Do you believe that there should be tort law responsibilities on the part of OpenAI for the way they handled the information they received respecting the Tumbler Ridge assailant and the information that they had?
So I appreciate.
Well, just repeat the question quickly. Sorry, the question was around the shooting in Tumbler Ridge and what OpenAI knew and didn't share or flag with respect to the assailant and its use of OpenAI.
Okay, so
Sorry,
Jeff, thanks for the question. And I want to focus on that tort law liability. And I'm not going to answer a question with a question. I just want to point out, and I've discussed this in my AI and law class on Monday, that there's two possible forms of liability. There's the liability to the parents whose children have been tragically killed, who may well sue, arguing that there was this neighbor duty that I've talked about earlier that OpenAI had to protect them, protect their children, or at least disclose to the police that they didn't. There is the other side of that coin, which is imagine, and the facts as we know them was that OpenAI cut this person off a number of months ago. They didn't report it to the police, and a number of months have passed. So that goes to tort law foreseeability issues and other things, and chain of causation issues that would get dealt with. But imagine that OpenAI had gone to the police, and imagine the police had come in and taken action, or perhaps injured the person involved in some sort of takedown, or hurt a family member. Obviously, we don't know, at that time, we wouldn't have known what was subsequently going to happen. There would be tort liability for those actions on the part of OpenAI potentially as well. And there's also the surveillance state aspects of this. In terms of, we all know so much about each other's business from a social media perspective, that is it reasonable to ask the tort law question? Is it reasonable as a neighbor to expect us to snitch on each other in a free and democratic society? I'd like to think that a court would say no. And from a corporate law standpoint, for better or for worse, corporations are persons. Now, there is a way around this. And the way around it is if the government decides that and I think this is a healthy way around it. The government would have to decide that it's going to pass a statute and create responsibilities in that statute on the AI companies, and would have to also indemnify the AI companies statutorily to ensure that there isn't liability for breach if they're going to put those responsibilities on them. What will happen then is that will be questioned in court by the AI companies, and I think by members of the public, on freedom of expression grounds. And there will be a determination eventually by the Supreme Court of Canada as to whether in a free and democratic society, this is a reasonable limitation on free expression. And I think that process, though slow, as you point out, is the right process if we want to have a rule of law regime. If we don't, then sure, we can make snap decisions and create all sorts of immediate accountabilities, and that's very dangerous.
Can I ask, so we've got time for one more question following. So if it's coming from the room, that's great. I'll cue you up just after this. So when you say free expression, in that scenario where it's a chatbot and it's an individual, the expression being protected is as between the chatbot and the individual?
So I don't think the chatbot, I think, rights belong to persons as of now. We may change that in the future. That's and it's not so much saying robots' rights as we can attribute rights, as we do to corporations, to AI. We can attribute rights to anything we want to. We've already done it with companies. Some people are arguing that it should be done with the environment. I'm not against that. Trees have rights, et cetera, et cetera. We do that with animals. So we can attribute those rights. But I think as of now, we're talking about the freedom of expression of what are essentially media companies, because that's what these AI platforms are.
No, well clarified. So you are our last question of the day. We're going to take the question and then do a quick thank you before we close, please.
I'm sorry if I deviate from the current trend.
Go ahead.
I'm someone who is very focused on digital rights and data protection ownership.
Okay.
So I'm currently engaging with this kind of research. So for that perspective, I thought this would be the great opportunity to ask the question. So, Professor, how do you think that privacy law is adapting these AI-generated technological things?
Want to repeat the question?
I heard online from our friends, thank you, that the question was being heard in their audio. So it should
Perfect.
be okay.
Okay, so is privacy law doing a good enough job with keeping up with technological change? Absolutely not. Not in a million years.
Stop, we're done. No, I'm just kidding.
Full stop. Look at the Privacy Act of BC. It hasn't been updated for years. We're going to need a whole bunch of amendments. We're going to need to deal with personality rights. We need to deal with whether our data outputs are, in a sense, our property or part of our personality. We all have massive data trails that we've created. Right now, by contract, all our data trails belong to the companies that are collecting them. You know, they're like dimes falling out of our pockets, and there are these, you know, these digital media companies that are, you know, scooping up the dimes behind us and saying it's our money. We need to rebalance that. And then I've said it before earlier today, I think the most important next piece from a privacy perspective is transparency and sort of announcing who you're dealing with. I think everybody should have a fundamental right to know that they're not dealing with a human being. And it should be really that. We label GMO foods. We can't label bots? Seriously? We can do better than this. Does that answer your question?
And it was right on track. I'm going to bring it down to a few examples that I think have hit not only classrooms, but public spaces recently. Wearables have started to come a long way.
Yeah.
I've had Meta glasses everywhere in my class. Zuckerberg tried to wear them, or his entourage tried to wear them into a courtroom. There was a leak. Bloomberg just put out Apple's new wearables. It's a pendant that can hear and see. There's
oh, that's leaked. They leaked that. Okay.
Which is rare for Apple. AirPods that are going to have camera functionality. So we aren't going to know. Oh, and the kicker, it's being paired with sort of the meta information as to when photos, or as this was part of the application, it's not commercial. It's being paired with when photos were tagged with names. So if you're looking at someone conceivably, you would know this is so-and-so who did this, that, and the other, which is frightening. Okay. And I think pairs well with our question, where we're seeing technology and hardware move so quickly. What do we need from privacy law?
Okay, so let's talk about that.
Yeah.
But first of all, I just have to say, I don't know why I would want AirPods taking pictures of the inside of my ears. It's not the worst use of technology. That would be other medical procedures where they set cameras into places that we don't want them to be.
It's like an ambient
but
knowledge of what your day is, presumably so that the AI can be much more functional.
But let me give you an actual real world example. Yeah. One thing that I do with all my classes is open websites and living syllabi, certainly in some of my courses, where you can link through to the materials. When I first did this, wonderful, kind people at the Center for Teaching, Learning, and Technology at UBC said, hey, do you want to track which students are opening the links and how much time they're spending reading your material? And I was mortified. I was absolutely mortified. And I said, absolutely not. And I now I have a slide at the beginning of every class that says, I do not collect any information on you. And I tell this story. But you will find literature, especially in the United States, pedagogic literature, that says you should be looking at this material because it may help you help the students or know which students may be suffering from distress and other things. I don't agree with that perspective. I think the key thing is disclosure. And that's my example of why disclosure is necessary. And if we don't have strict rules on transparency and disclosure, then companies are going to keep track of this stuff. And I would argue, if I was acting for OpenAI or anybody else, the more you collect this information, the greater your tort liability potentially is. So disclosure is in fact in your interest. If I could deliver a message to anybody, and not disclosure via some terms of service agreement that nobody reads, but really clear.
I think that's comforting, promising. I've actually saved us a bit of time. So we have one last question that I see coming up many times online, and where I'll leave our conversation. Are we at a point now where folks in practice will be seen as deficient, or, I mean, the word negligent was used online, if they aren't at least familiar and, depending on the question, conversant, able, competent with the use of AI tools in practice? Is it an expectation?
I think it is going to be a regulatory expectation in time. I think it has to be an expectation we have of ourselves to be successful. I'm going to give you a very brief example.
Okay.
When I came into the practice of law in the early 80s, the very early 80s, 1981 is when I arrived as an articling student in Vancouver. The highest form of the lawyer, of the legal mind, was if you were, quote, learned in the law, right? What is learned in the law? You knew the precedents. You knew what the law was. That keeps changing. And I would say by the year 2000, some of my colleagues who I practiced with at that time, being a really good lawyer was about strategy and strategic advice to clients. And it wasn't learned in the law. It was knowing the law enough to be able to navigate through it. Well, now in the world of AI, everybody's going to know what the law is. You don't even have to be a lawyer in 5 years, assuming AI transgresses some of its current inference problems. You won't even have to be a lawyer to have an accurate description of the law. So now we're even beyond the strategic. I think we go to the creative. This answers an earlier question of what we have to do. But with students, we have to teach them to be creative with the law. But the regulator's expectation has always been that the lawyer is has a responsibility to the public to serve the public and the rule of law competently. And I just don't see a way around using all the necessary tools to do so. There may be a few lawyers who are so surpassingly brilliant that they won't need AI, but there won't be many, and they will be very old.
I consider that a complete answer. If you don't online, feel free to contact Jon. He is very generous with his time, thinking, and creativity in answering these questions. Having had the pleasure of having this conversation in many different forums in many different ways. So before we go, thank you to everyone online. It's been engaging, interesting, and wide-ranging, which is what you expect with Professor Festinger. So I hope you've learned something and got what you wanted out of the session. Again, feel free to give us, Jon, an email or a connection if you're looking for further thought in the room. Thank you. I know there's a lot of competition for your time, and you chose to spend it here. So we appreciate you. And to Jon.
And thank you, Elicia.
Thank you. Oh,
fabulous.
I enjoy our conversations immensely. So have a lovely day, and we will see you all hopefully soon in the future.